Welcome to the Deep Dive. We're here to transform vast stacks of legal history and ancient source material into immediately actionable knowledge, customized just for you. Today, we're setting aside the usual tales of Roman legions and political intrigue. Instead, we're looking at something quieter, maybe, but arguably more enduring. The Roman intellectual mind, specifically through the lens of its legal system. We are diving deep into a uniquely Roman institution, the jurists.
That's right. Our mission today is really to get under the hood and explore the intellectual architecture of Roman law. You know, when you think of ancient law, maybe Athens comes to mind first. And there, the legal system was really driven by rhetoric, by persuasion, emotion, politics. Think big courtroom speeches.
Absolutely. Athens elevated the orator, right?
Mm-hmm.
Got like Demosthenes, Aeschines, masters of swaying huge juries, cases decided by hundreds, sometimes thousands of citizens. Very democratic, very public, very, well, theatrical almost.
Exactly. Rome, though, went down a different path. It developed what you could genuinely call a science of law. This wasn't primarily about fiery speeches in the forum. It was about rigorous scholarly reasoning. And the key figures here were the jurists, people like Papinian, Ulpian, names you might recognize. Their work built a legal tradition so strong, so sophisticated, it eventually became the foundation for modern civil law in much of the West.
That contrasts rhetoric versus science that feels really central to understanding Rome's unique contribution here.
It really is. Athens had orators, Rome had jurists, and these jurists weren't necessarily the lawyers, the advocati, arguing cases day to day.
Oh, so they weren't courtroom lawyers.
Not always, no. Many were scholars, deeply immersed in interpreting law. They spent their time analyzing statutes, customs, past decisions, systematizing it all. They were trying to turn this collection of rules and rituals into a coherent intellectual discipline.
So the engine of legal development wasn't really the legislature or the assemblies in the same way as maybe we think of it now.
In many ways, no. It was the written opinions, the responsa, the detailed analyses of these elite scholars. They were often working away from the immediate heat of politics, crafting the concepts, the definitions, the legal tools needed to make the system work.
Creating the mental algorithms, as you put it earlier, that's a great way to think about it. They built the operating system for Roman law.
That's a fantastic analogy, and it's an operating system that proved incredibly durable, long outlasting the empire itself. They were, kind of the anonymous architects of this massive legal structure.
Okay, so let's unpack this legacy. A system built on scholarly opinion needs recognized authorities.
Mm-hmm.
Who are these key figures? Who formed this pantheon of jurists?
Well, when we look at the texts that survive, especially the later compilations like Justinian's Digest, a core group emerges. Their opinions carried immense weight. You have Gaius, famous for his introductory textbook, The Institutes. Then the real heavyweights from the Severan period, like Ulpian and Papinian, also Paul, Pomponius.
Julian, Modestinus, Marcellus.
Exactly. Labeo, Celsus, Tryphoninus, Scaevola. The list goes on. These weren't just random names. Their collective work across centuries formed this continuous stream of legal thought, this ongoing debate and refinement.
And this massive body of work, all these opinions and debates, eventually gets funneled into Justinian's Digest in the 6th century A.D. Now, this wasn't just like archiving old legal documents, was it? It sounds much more ambitious.
Oh, incredibly ambitious. It was a monumental act of legal scholarship and, importantly, legislation. Imagine, they took something like 3 million lines of text from nearly 2,000 works by about 39 different jurists.
Wow.
And condensed it all down into roughly 150,000 lines, organized into 50 books. A team led by the jurist Tribonian, with others like Theophilus and Dorotheus, had this mammoth task of sorting through centuries of legal thought.
And this is where, as you mentioned, it gets really interesting, because they weren't just compiling, they were actively editing, shaping the past.
This is the absolute key. They weren't just curators. They had a direct mandate from Emperor Justinian to refine the law. Their instructions were explicit: amplify or cut anything they deemed superfluous, imperfect, or unsuitable for their own time.
So if they found contradictions between, say, Papinian and Ulpian,
they didn't just present both sides. They had to resolve the conflict. They were told to choose what seemed better, what was more useful, and set that down as the single authoritative rule. The goal was to create one unified, coherent legal code from this mass of sometimes conflicting historical material.
But hold on, that sounds, isn't that a bit dangerous? Erasing centuries of debate. How did they justify essentially rewriting the words of these revered ancient authorities while still claiming their authority?
They justified it primarily on the grounds of utilitas practical utility and the need for legal certainty. The idea was that the name of the original jurist Papinian, Ulpian, whoever, guaranteed the quality of the reasoning, the pedigree. But the final text in the digest represented the perfected version of that reasoning, made suitable for 6th century needs.
So they could change the text but keep the name.
Precisely. This is the concept of interpolations, later additions or alterations to the original texts. We even know they did this with imperial laws, the constitutions. If an old decree from an emperor seemed impractical or outdated, they'd revise it.
They'd revise the emperor's own words.
Yes, but carefully. They'd keep the emperor's name attached to maintain the formal authority, but they would amend the text itself, emendations, to reflect what they considered the law's true intent, or, more accurately, its necessary usefulness for their current society.
So tradition gives way to practicality. The digest becomes the ultimate purified source. No going back to the originals.
Exactly. Justinian actually forbade anyone from citing the older texts or comparing them to the digest once it was promulgated. The digest was the law, full stop. It wasn't just a historical collection, it was enacted legislation. And that act cemented the legacy of those classical jurists, ensuring their way of thinking, albeit filtered and edited, would dominate legal systems for the next millennium.
That level of centralized intellectual authority is just staggering. And it highlights how these jurists managed to keep a system rooted in ancient, sometimes rigid, rules that plaque the civil law flexible enough for a vast, complex empire. You mentioned they use specific tools for this, often involving the praetor and this idea of equitus or equity.
Yes, the orators civil could be very formalistic, based on old statutes like the 12 Tables and specific verbal formulas for legal actions. Sometimes applying these rules strictly would lead to results that were just obviously unfair.
Technically correct, but wrong.
Exactly. So the jurists, working often through the praetor's edict, developed mechanisms to introduce fairness or equity without formally overturning the old laws.
Okay, let's focus on a key tool here, the exceptio, the legal defense. Gaius talks about this, right?
He does, and it's fundamental. The exceptio was a crucial innovation. It was basically a clause inserted into the formula that guided the judge. It told the judge, okay, even if you find the defendant is technically liable under the civil law, you must dismiss the case if condemning him would be unfair or inequitable.
So it shifted the focus. Not just, did he do the thing, but is it fair to hold him liable?
Precisely. It allowed considerations of good faith, fraud, or duress to enter the legal equation formally.
Can you give us a concrete example? The outline mentions the exceptio doli mali, the defense of bad faith or fraud. How did that work?
Okay, imagine this classic scenario. You and I make a formal contract called a stipulatio. It's a very old verbal contract. Let's say I promise to lend you 100 sesterces, and you formally promise to pay me back on a certain date. We go through the required question and answer ritual.
Okay, got it. Formal promise made.
Right. But then I never actually give you the money. I just don't hand over the loan. Now, under the very strict old Honicus civil, your formal promise to repay still stands. It was correctly made. Technically, I could sue you for the 100 sesterces you promised to repay, even though you never got them.
That's completely unjust.
Absolutely. And this is where the praetor, guided by the jurists, stepped in. They introduced the exceptio doli mali. If I sue you, you can raise this defense. The judge's formula would then include instructions essentially saying, condemn the defendant only if it does not appear the plaintiff acted fraudulently in bringing this claim. Since suing for money never lent is clearly fraudulent, dolus malis means malicious deceit, the judge would have to dismiss my case.
So the exceptio acts like a safety valve, letting fairness override pure formalism.
Exactly. It injects morality and good faith into the system, making it workable. It shows the jurists weren't just technicians, they were wrestling with justice.
But their reasoning wasn't purely abstract philosophy, was it? The principle of utilitas public utility, or the state's interest, seems to have been a very powerful driver, too.
Oh, absolutely. Utilitas publica was a major justification for legal rules and state actions. It shows how Roman legal thought was deeply pragmatic, tied to the needs of governing the empire. It could even override other ethical considerations.
The outline mentions Augustus and the conspiracy of Capio and Murena. How does public utility play out there?
Right, that was in 22 BC. Capio and Murena were convicted of conspiracy against Augustus. They were supposed to go into exile, but they delayed. Augustus sent agents who tracked them down within Italy and executed them. This caused a bit of an uproar. It looked like summary justice, maybe even vengeful.
Acting in anger, perhaps.
Which is frowned upon, especially by Stoic philosophy, which influenced many Romans. But Dio Cassius, the historian, reports Augustus's defense. He argued that the pursuit and execution weren't done out of anger, but were necessary for the public good, utilitas publica. Essentially, the security of the state and the need to decisively crush conspiracies trumped the philosophical ideal of not punishing in anger. The jurist would have provided the legal framework to validate this kind of state necessity argument.
So utilitas publica becomes a kind of legal trump card for state action, grounded in practical necessity rather than pure ethics.
You could see it that way. It reflects the Roman focus on order, stability, and effective governance. And this pragmatic, utility-driven mindset wasn't just for major political crises. It shaped the everyday legal system, particularly through the relationship between the jurists and the praetor.
Okay, so what does this all mean for how the law actually developed day to day? How did this collaboration between the legal scholars and the political magistrate, the praetor, work?
It was a really dynamic relationship. The praetor was an elected magistrate holding office for just 1 year. At the start of his term, he issued his edict, basically. A public notice outlining the legal remedies, the types of lawsuits he would allow during his year.
And the jurists were advising him on what should be in that edict.
Heavily. The edict became the primary vehicle for legal innovation. The jurist would analyze the existing res civil, identify its gaps and problems, and then advise the praetor on new remedies needed for emerging situations, especially in commerce. They wrote extensive commentaries on the edict, interpreting the praetor's intentions and clarifying the scope of the new actions.
So the praetor's edict, fueled by juristic interpretation, became this constantly evolving layer of law sitting on top of the old civil law.
That's a perfect way to put it. The praetor couldn't formally change the auxietus civil. Only legislation could do that. But he could grant new types of actions, often called actions utiles, useful actions, or actions in factum, actions based on the specific facts of the case, not on a pre-existing civil law right. Pomponius, for example, notes in his commentary on the edict that the praetor specifically announced he would crack down on dishonesty by ship captains and innkeepers.
Signaling new, stricter rules were coming for those professions.
Exactly. This signaled the introduction of special liability rules to protect customers, going beyond what the standard contracts of deposit or hire offered. The jurists helped craft these rules.
So this praetor-jurist partnership was like an engine for legal development, keeping the law relevant without needing constant, slow legislative updates.
It was incredibly effective. It allowed Roman law to adapt to the needs of a huge, diverse empire with complex trade and social interactions. It kept the system flexible and sophisticated.
Right. Speaking of complexity, let's dive into one of those specific areas Section 4 mentions, the liability of people like innkeepers and ship owners. This seems like a great example of the jurists really getting into the weeds.
It really is. Ulpian and Pomponius, among others, discuss this in detail. There was a special praetorian action against innkeepers. Nota, capones, stabulary, shipmasters, innkeepers, stablekeepers. They were held responsible for the property that customers brought onto their premises in the course of business.
Okay, seems reasonable.
Yeah.
But the legal puzzle was, why did they need a special action for this? Weren't there already standard contracts like deposit or letting and hiring that could cover lost or stolen goods?
That was exactly the debate among the jurists. Why create a new remedy if existing ones like actio depositi, for goods deposited, or actio locati, for goods related to hire, existed? Under those standard actions, the innkeeper or ship owner would typically only be liable if you could prove they were negligent or acted fraudulently. Culpa or dolus.
So proving fault might be difficult for the customer.
Very difficult, especially if, say, another guest stole your belongings or an employee was careless. So the consensus, articulated by jurists like Lebio and Pomponius, was that the praetor introduced this special action to impose a much stricter standard of liability. The point was to make these business owners liable in almost all circumstances, regardless of their personal fault. It was a public policy decision to ensure safety and trust in these essential services.
So basically strict liability. If something went missing while under their care, they were liable. End of story.
Pretty much. Unless they could prove the loss was due to vis mare, an overwhelming, unavoidable force.
Like a natural disaster.
Right, or a shipwreck or an attack by pirates, things genuinely beyond their control. Lebio specifically says that if the loss was due to shipwreck or piracy, it's fair, non est iniquum, that the owner gets a defense. But short of that, even if the goods were stolen by a third party or damaged without the owner's direct negligence, the owner was generally liable. Lebio called their liability almost unlimited.
That's a really high bar. It shows the praetor and jurists using law quite aggressively to shape commercial behavior.
Definitely. It underscores the utilitas publica idea. Again, protecting the public using these services was deemed crucial.
Okay, let's shift from the marketplace to the Roman household, another area of incredible legal complexity. The potestas system, the power of the head of the family, the paterfamilias.
Ah, yes, patria potestas. This was a cornerstone of Roman family law, and as Gaius points out, it was considered part of the Iulicis Gentium, the law common to all peoples, although Roman potestas was particularly strong. It gave the paterfamilias significant authority over his children, filii familias, and, classically, absolute power including life and death over his slaves, sir.
Legally, slaves were often treated as property, right? Anything they acquired belonged to the master.
Correct. A slave was in the potestas of the master. Even technically complex ownership situations, like having bonitary title, practical ownership, without full quiritaire title, formal ownership, still placed the slave under the master's control.
Yet, despite this seemingly absolute power, the outline suggests that imperial law, shaped by the jurists and emperors, started to put limits on it. So what does this all mean for the slave's actual situation? Were there protections?
Yes, this is a crucial development in the imperial period. While the principle of absolute power lingered, its practical application was significantly curtailed. A very important ruling came from Emperor Antoninus Pius. He issued a constitution stating that a master who killed his own slave without cause could be punished just as if he had killed another person's slave, essentially, making it a crime.
That's a huge shift from property right to potential homicide charge.
It is. And there was more. Antoninus also ruled that if a master treated a slave with excessive cruelty, saevitia, making their life unbearable, the master could be forced to sell the slave. The jurists rationalized this limitation by drawing an analogy. Just as a declared spendthrift, prodigus, could be barred from managing his own property because he was wastefully destroying it, a master acting with extreme cruelty was, in a sense, abusing his right and destroying his property, the slave, justifying state intervention.
Interesting. They frame it in terms of property mismanagement, not inherent human rights, but the effect is protective.
Exactly. It's a legalistic way to achieve a moral end, typical of the juristic method. The reasoning was often one ought not to misuse one's right.
Okay, now let's connect this potesta structure to the economy. How did the system handle debts or contracts made by people under power, like sons or slaves? This brings us to the Actio de Peculio.
The peculium. This was vital. The peculium was essentially a separate fund or collection of assets that the paterfamilias allowed a son or slave to manage, almost like a small business or personal account. If that son or slave entered into contracts related to the peculium, creditors could sue the paterfamilias using the Actio de Peculio.
But the father or master wasn't fully liable for everything the son or slave did, right?
Right, and that's the key. The paterfamilias' liability was limited to the value of the peculium at the time of judgment. It functioned a bit like limited liability today. It allowed the head of household to empower dependents to engage in commerce without risking the entire family fortune on every transaction.
Smart. But it must have led to tricky questions about when a contract was actually related to the peculium.
Absolutely. This is where jurists like Celsus and Julian debated intensely. Take the example of a son or slave acting as a surety, guaranteeing someone else's debt. Was the paterfamilias liable via the peculium? The jurist said you had to look at the purpose. Was the guarantee made to benefit the peculium somehow, maybe to secure a business deal for it? Or was the son slave just doing a personal favor, completely unrelated to the peculium's management?
So, like an early form of agency law, was the dependent acting within the scope of their employment regarding the peculium?
Precisely. If it was just a personal favor, generally no liability attached to the peculium. However, Julian points out a subtle distinction noted by earlier jurists like Sabinus and Cassius. They argued that a father might always be liable on the peculium for his son's guarantee, even if it didn't directly benefit the fund.
Why the difference between son and slave?
The reasoning seemed to be the unique nature of the father-son relationship, perhaps implying greater implied authority or a stronger moral obligation compared to the master-slave property relationship. It shows the nuances they dealt with.
And liability could stick, even if the original reason was shaky.
Yes, procedural law was powerful. If a son was sued, even perhaps improperly, and a judge issued a formal judgment against him, that judgment itself created a new legal obligation. The father then became liable up to the value of the peculium based on the judgment, even if the initial claim wasn't strictly related to the fund. The legal process itself solidified the debt against the peculium.
Wow, the formality of the judgment overrides the substance. Okay, moving beyond finance, let's look at another complex family duty. Tutelage, or guardianship. This seems like another area ripe for juristic analysis.
Definitely. Tutelage, tutela, was the guardianship, usually of minors or sometimes women, who lacked a paterfamilias. It was often a compulsory public duty, usually unpaid, and the jurists spent a lot of time defining who had to serve and who could get out of it.
What were the grounds for exemption?
Modestinus and Tryphoninus lists several. For a freeborn citizen, you could be excused if you were already managing 3 other tutelages or curatorships. Having children was a big one under the Aegitus Laborum policies. Having a certain number of children, often 3, sometimes 5 depending on context and status, granted various privileges, including exemption from tutelage. Advanced age, typically 70 years, was another excuse. Certain public offices or military service could also exempt someone.
And social status. Did being a senator get you off the hook?
Not automatically. A senator might still be required to be a tutor, especially for the children of another senator, unless they had one of the other valid exemptions like age or number of children.
And just like with the peculium, the jurists were keen to stop people dodging these duties through legal tricks.
Very much so. Modestinus gives this great example of what he calls knavery, caliditas. Imagine a son is appointed tutor. His father, wanting to get him out of this burdensome duty, refuses to provide the legally required security or guarantee, satisdatio, for the son's proper management of the ward's property. The father's refusal could technically invalidate the appointment, freeing the son.
A loophole.
Exactly. But Emperor Hadrian closed this loophole. He decreed that if a father tried this trick, the father himself would be compelled to take over the tutelage. It shows the emperors and jurists working together to ensure these protective systems weren't undermined by clever legal maneuvering. The goal was always to make the system work effectively and protect the vulnerable ward.
That drive for practicality reminds me of the point about property law, Henry Sumner Maine's insight regarding res mancipi and res nec mancipi.
Yes, Maine's observation is brilliant. Roman law initially made this sharp distinction. Res mancipi were the really important traditional forms of wealth in early Rome. Land in Italy, slaves, draft animals, rustic servitudes. Transferring these required a very old formal ceremony called mancipatio, with witnesses, scales, bronze, very ritualistic.
And res nec mancipi.
That was basically everything else. Money, furniture, clothes, imported goods, land outside Italy. These lesser things could be transferred simply by physical delivery, traditio, with the intent to transfer ownership. Much simpler.
So the simple method was used for the unimportant stuff initially.
Right. The complex ritual was reserved for the things that really mattered in the ancient agricultural economy. But Maine's point was that, over time, as Roman society became more commercial and complex, the sheer convenience and efficiency of simple traditio became obvious. The jurists, focused on utility, increasingly found ways to give legal effect to informal transfers, even of res mancipi. Eventually, the simplicity used for unimportant goods became the model, highlighting how clunky and outdated the old mancipatio ritual was. Practicality won out over ancient tradition.
Another win for legal science, refining away historical complexity for efficiency.
A constant theme in Roman legal development.
Okay, we've seen the sophistication, the drive for utility. But we have to confront the harsher side. Section V highlights a stark reality. By the later empire, Roman law formally entrenched vastly different punishments based purely on social status.
Yes, this is undeniable and frankly disturbing. By the Severan period, late 2nd, early 3rd century AD, the distinction between honestiores, the more honorable upper classes, and humiliores, the lower common folk, became a fundamental principle of criminal law.
So what did this mean in practice? How were the honestiores punished?
For the upper classes, senators, knights, local elites, veterans, the penalties were generally less severe and less physically brutal. Execution was very rare. More common punishments involve loss of status or exile, things like modio origine, expulsion from the senatorial or equestrian order, disqualification from holding office. Exile could be relegatio, banishment, maybe temporary without losing citizenship or property, or the more severe deportatio, lifelong exile, loss of citizenship, confiscation of property. This effectively made them civilly dead, but they usually avoided physical punishment or pretrial imprisonment.
And for the humiliores, the common people.
The contrast is stark. They faced the summum supplicium, the highest penalty, which meant death, often in deliberately cruel and public ways. Crucifixion, being burned alive, thebus ori or crematio, or being thrown to wild beasts in the arena, damnatio ad bestias. If they received a life sentence, it usually meant condemnation to hard labor in the mines, damnatio in metallum, which was brutal and often fatal.
And corporal punishment, beatings, torture.
That was standard for humiliores. Scourging was common. And while torture had traditionally been reserved for slaves to extract evidence, by the 2nd and 3rd centuries, free citizens of low status, humiliores, were increasingly subjected to torture during investigations, especially for serious crimes. The anestiores were almost entirely immune from this. The system was explicitly designed to inflict terror and pain on the lower classes, while maintaining a degree of dignity, even in punishment, for the elite.
So status could literally mean the difference between exile and being burned alive for a similar offense. It's a brutal reminder of Roman hierarchy. But even within this deeply unequal system, there was still one layer of protection that mattered: Roman citizenship itself.
Yes, Roman citizenship, civitas, still carried significant weight, providing a baseline of rights against arbitrary official action, regardless of whether one was honestior or humilior. The key protection, codified in laws like the Lex Julia Divi Publica, was immunity from summary corporal punishment by magistrates. A Roman citizen could not legally be beaten, scourged, or bound before being properly tried and condemned by a court.
And this is famously illustrated in the New Testament with the Apostle Paul.
Exactly. The accounts in Acts provide vivid examples. When the Roman commander in Jerusalem orders Paul to be scourged to find out why the crowd is rioting, Paul reveals his citizenship.
He asks, "Is it lawful for you to scourge a man who is a Roman and uncondemned?"
Right. And the reaction is immediate panic. The centurion rushes to the commander, warning him Paul is a Roman citizen. The interrogation stops instantly. Similarly, in Philippi, after Paul and Silas have been beaten and imprisoned by the local magistrates, they reveal their citizenship the next day. The magistrates are described as being afraid when they realize they've illegally beaten uncondemned Roman citizens. It shows this right was taken very seriously.
So citizenship offered a crucial procedural shield, even if the ultimate punishment might still differ based on status after conviction.
Precisely. It protected against arbitrary violence by officials, ensuring at least the formality of due process.
We've traced quite a path from the philosophical foundations, through the intricate mechanics of equity and liability, to the stark realities of social status in law. It feels like the Roman jurists truly did achieve something remarkable.
They really did. They transformed law. They moved it away from being solely a matter of ancient religious custom or purely political debate, like in Greece. They established it as a distinct intellectual discipline, a science with its own methods, its own specialized language, and its own internal logic.
Building this rational framework, classifications, principles of interpretation, concepts like equity and utility, that was their core achievement.
I think so. The specific rules changed over time, of course. But the system of thought they created, how to analyze a case, how to define rights and obligations, how to balance competing principles, that's what proved so enduring.
And this intellectual structure, the concepts for property, contract, family law, liability, this is what got picked up later and formed the basis of modern civil law.
Exactly. When legal scholarship revived in medieval Europe, they rediscovered Justinian's Digest. The work of the Roman jurist provided the ready-made sophisticated framework they needed. That framework, refined over centuries, still underpins the legal systems of much of continental Europe, Latin America, and parts of Asia and Africa today. Their intellectual DNA is still with us.
So the jurists represented a fundamental shift. Legal authority grounded in reason and scholarship, not just political power or popular vote. And this leaves us with a final thought for you, our listeners, to ponder. When law makes that transition from being primarily a subject of public debate and oratorical persuasion, like in democratic Athens, to becoming more like a complex scientific text interpreted and refined by a specialized class of experts, the jurist, what do we gain? And perhaps what might be lost in the relationship between the everyday citizen and the machinery of justice? Something to think about.